So, hello everybody, and welcome to Law 2024 Online. Today's discussion, titled Residential Property Shaped the Debate, with me, Lawrence Howland, David Keithley, and Richard Snape. So today's Q&A is due to last for about an hour, and I'm going to be covering your pre-submitted questions. And just so you know, a recording of the session today will be available on the website within the next few days, so please do keep an eye out for that. So by way of introduction, my name is Lawrence Howland. I am the Director of How Compliance Limited, which is a firm that provides compliance services to law firms. And I'm also the Director of Risk and Compliance of Buckles Solicitors. A little bit about my background. I spent 3 years with the SRA and 30 years with HMRC, previously in Customs and Excise, as a financial investigation SIO. So my speciality really is compliance and financial investigation. From 2010 to 2014, I was also the Fiscal Crime Liaison Officer to the British Embassy in Beijing. My academic background, I'm MSc in Financial Investigation, and I have also spoken and written extensively on financial crime typologies. Most recently, if you read a recent version of The Economist, I've been quoted in an article there about Chinese underground banking. So I think that's enough about me. Let's talk about the two gentlemen who I'm hosting today. So David Keithley. David was admitted as a solicitor in 1982, and until he retired from full-time practice, he was a partner and the head of residential property at a Legal 500 firm. And David now uses his extensive experience and understanding of practical conveyancing to cut through all those academic niceties and try and make things relevant for busy practitioners. He's also one of the contributing editors to the Law Society Conveyancing Handbook. And so far as Law 2024 Online is concerned, David has done other sessions, including one on listed buildings, issues for conveyancers, and one on build-over agreements, septic tanks, and lateral drains, both this year. Turning to Richard Snape has been the Head of Professional Support at David Jones Bold since 2002. And he speaks at all kinds of courses for law societies all over the country, various public courses, in-house seminars within solicitors' firms. And he's also spoken extensively to local authorities and to central government bodies. And Richard's area of specialism includes commercial and residential property, in particular in relation to local government law, issues with conveyancing, development land, commercial property, and encumbrances in relation to land. And so far as Law 2024 Online is concerned, Rich has also done sessions for the Leasehold and Freehold Reform Bill and its effect on conveyancing, and also the Building Safety Act 2022 and some of the other critical post-Grenfell legislation. Again, both sessions that he's done in 2024. So David and Richard, welcome to the session today. Nice to have you with me. And I'm going to turn to the pre-submitted questions that we've had. And the first really directed at David is about the Flood and Water Management Act. Is it known when Schedule 3 of the Flood and Water Management Act 2010 will finally be brought into effect, David?
The short answer is no. The longer answer is that it's expected during the course of this year. Essentially, the schedule was not implemented when the rest of the Act came into force. There was a government consultation last year, or back into 2022 and into last year, about whether it should now be brought into effect. The overwhelming consensus of that consultation was yes, it should. The minister in charge at the time, Therese Coffey, responded acknowledging that the outcome of the consultation and the recommendations, and simply said that they would be legislating to bring the schedule into effect, and that it was anticipated that would be during the course of this year. We don't know when, presumably bearing in mind the current parliamentary term. It may well be obviously before the summer. If not, then depending on when the election is, and if there's still the political appetite for them to do it, then you would expect it to be sometime before the general election. Effectively, what the schedule will do is remove from developers the automatic right to connect to the public drainage system. And in order to connect their developments to the drainage system, they'll have to demonstrate that they have either included a sustainable urban drainage scheme into their development, or that it's accepted that it is not feasible for that particular development. So it will have quite some profound effects once it does come into effect. But yeah, as I said, we don't know when, other than it is expected sometime this year.
Thank you, David. So we're keeping our fingers crossed.
I do remember it being expected to come into force in 2011 as well, though. So
it was, yeah.
So slightly overdue, we can say.
Yeah.
It does. Yeah, the official light it comes into force this year, but I mean, it's a lot of resistance from the utilities.
Yeah, from the developers particularly.
And the developers, yeah.
So fingers and toes crossed. Okay, thanks very much. So Richard, a question for you now. Has the problem with qualifying leases and leasehold extensions been solved?
In a long-winded way, and there are a few issues still with it, but yeah, I mean, I'd mentioned the background for the setting in its context. To be a qualifying leaseholder under leaseholder protections under the dreaded Part 5 and Schedule 8 of the Building Safety Act, which is the worst drafted piece of legislation I've ever come across. I was mentioned in the Sunday Times, and the Times is saying that actually, David.
Yeah, I saw that, yeah.
But,
you're not alone in that comment, Richard. So.
Well, bang goes my MBE.
Yeah.
It's basically to be a qualifying leaseholder. The lease had to have been in existence before February the 14th, 2022, which is when everything crystallized for these things on Valentine's Day. And they obviously missed a huge problem, and quite an obvious problem to start off with. Anybody who goes through a lease renewal, either statutory or voluntary, it's a brand new lease. It's a surrender of an existing lease and a brand new lease. And so as it stood, everybody who was a qualifying leaseholder on February the 14th, 2022, went through a leasehold extension, suddenly lost their qualifying status. And it's just over a year ago, in April of, I think it was April of 2023, the government basically said they realised that there was a problem, and they would legislate as soon as they could to solve the problem. I was actually expecting it to be a part of the Leasehold and Freehold Reform Bill, which was being mooted last sort of May time, which would delay things enormously. But there's something called the Levelling Up and Regeneration Bill was going through Parliament, which on October the 26th last year became the Levelling Up and Regeneration Act. And there's a lot of debate about it. I remember talking to David about it beforehand, when it was passing through Parliament, but they just added at the last moment, so it was a bit of toing and froing, but they added at the last moment a section, I think section 243, of this huge piece of legislation, nothing to do with the rest of the legislation, that gave a whole list of situations where there'd be a connecting lease, and basically that's where you go through a statutory or voluntary extension. Didn't come into force. I say that the bill received the royal assent on October the 26th, and it didn't come into force until Boxing Day, 2 months hence. So Boxing Day and Valentine's Day are important for the Department of Levelling Up. They do like their significant dates, and it should have been solved. There are a few issues with it, and it should have been solved retrospectively back to February the 14th. I don't know if you want to add anything to that, David.
No, I mean, I agree there was some toing and froing. It's what surprised me was that before the government laid their own amendment, there was a proposal in the House of Lords, which appeared to do exactly the same as it ended up doing on the government amendment. The Lords voted in favour of that amendment, but all of the Conservative peers present at the time voted against it. So it was clearly a government whipped operation.
Yeah, it was.
And then they did pretty much exactly the same thing. When
they said there was a slight change in that originally the legislation applied to surrender, it was surrenders and re-grants, when it's where it's a surrender and a grant of a new lease and not an re-grant of the existing one. Well, that's what nitpicking, really.
It was just there seemed to be no logic to why they threw out the House of Lords amendment, and other than, as I say when I lecture on these things, that they replaced a a perfectly serviceable clause with one 4 times as long. But
yeah, basically, it is very long-winded.
Yeah.
I remember looking at it because, you know, I think I had a course which involved that, and, you know, a day or so later. And so you're just thinking, is there some little pitfall here that I've missed? Because it is, it's a huge section, much longer than it needs to be.
Yeah. No, I mean, I think, other than that, I think you're right. It's largely agreed, but initially, I mean, when I looked at it originally, I thought maybe they'd only backdated it to the 26th of June, which would have meant that any lease extensions between February and June would have been outside of the Act. But looking at it in a bit more detail now, it's clearly backdated to the 14th of February. So
there are issues about, you know, people who'd sort of already tried to deal with it, and people who'd lost money as a consequence and so on. But I think going forward, well, at least that little problem solved. It's a shame that the other 1,000 problems in the leaseholder protections aren't solved yet. But yeah,
there we go.
Okay, thanks very much for that. And again, I'll keep my fingers crossed that your MBE chances aren't completely out of the window, Richard. Thank you. So a question for David now about an area that I know he's got particular expertise in, which is septic tanks. And the question that's come in, David, is if a septic tank is already in place and as a result of a sale, the tank then needs to be replaced, who's responsible for that? Who's responsible for paying for the replacement, and by when must the replacement take place?
Okay. Essentially, the point here is that the regulations regarding septic tanks changed dramatically. Essentially, any septic tank in place before September 2015, if it drained to a watercourse, then it must now be replaced. There was an interim period allowing them to be replaced by December 2020, or when the property was next sold. Well, clearly those dates have passed. So if you do have an existing septic tank which drains to a watercourse, then the sale of that property will trigger the requirement for a replacement. The Environment Agency basically say that the responsibility for who does it is a matter of negotiation between the seller and the buyer. The only comment that the Environment Agency make is that they regard it as a requirement that the tank be replaced within a reasonable time of completion of the sale, and they have indicated that in their view a reasonable time is 12 months. So basically it boils down to the tank has either got to be replaced during the course of the sale transaction, or more likely, I suspect, replaced by the incoming purchaser after completion. But they'd have to do it within 12 months. In terms of the cost, that's purely a matter of negotiation between the seller and the buyer. So if the seller and the buyer obviously need to come to some arrangement about it. If you're acting for somebody in that situation and you happen to be the buyer, then one thing to bear in mind is that replacing a septic tank is not always that straightforward, and can be quite costly. And so, if you're acting for somebody in that situation, you really ought to be insisting that they have a full septic tank survey carried out before they commit themselves to the transaction, and have a realistic estimate of the costs involved, because replacing a tank is not just a question of sort of digging up the existing one and popping a new one in. Often there are access issues. And particularly if the septic tank, for example, is not on the land that you're buying, if it's a shared tank, or the tank itself is on land belonging to somebody else, then you may have issues about access to and obtaining the rights to get to the tank and to dig it up. Particularly if, for example, you need the tanks on somebody else's land and you need to replace it with a bigger one. The existing landowner, of course, might say, well, sorry, you can't. You can have a tank the same size or in the same place, but you're not digging a bigger hole than you had before. But it is essentially, it boils down to negotiation. The Environment Agency say that 12 months is a reasonable timescale. So I think both of those is probably the response to that.
And presumably, David, when we talk about reasonable timescales, factors like where the tank is, how easy it is to get to, that are all going to affect what might be regarded as reasonable in the circumstances?
I think possibly, yes. I mean, it's obviously that's going to be an issue for in each individual case. I suppose the part of the issue is the Environment Agency would say that those items ought to have been established during the course of the negotiation and should be known about. I mean, for example, if you need access to somebody else's land, then and you need to replace a tank, then any sensible purchaser's solicitor is going to require that those agreements be put in place before their client commits themselves to the purchase. Because they've got a situation if they commit themselves to the purchase without having obtained those necessary permissions, and then they don't get them, they've then got a real problem. In that their only option would be to, I suppose, put a tank on their own property. Well, probably the reason the tank's not on their own property in the first place is it's not possible or not feasible for a tank to go onto their own property. So, those issues I suspect, would need to be resolved beforehand. And one would hope that once they've been agreed before the transaction actually completes, that getting somebody out to replace the thing within 12 months ought to be feasible. But again, I appreciate there will be slightly differing circumstances. It's not a hard and fast absolute, it must be done. The Environment Agency just simply say in their mind a reasonable time frame is 12 months. But obviously there will be different circumstances.
I've seen them cost up £50,000 to replace.
Yeah, absolutely. Yeah.
I've seen it cost a lot less than that as well. I think the two other things. I mean, the other problem, it doesn't apply to Wales. That's an issue, because English and Welsh property law are getting so different. But your average client doesn't have a clue whether they've got a septic tank or a small treatment plant or a cesspit. They just don't know.
Yeah, indeed.
Or where the septic tank drains, so you need a specialist drainage report.
You do have a specialist survey. Certainly any property where you're buying, where there's a private drainage system, then you really must insist that clients have a full drain survey, and that the existing system is emptied before that survey is carried out. Because only once it's empty can a proper investigation be taken place as to whether it's draining properly, where it's draining to, whether there are any faults with it. So there's going to be a cost on the seller, if nothing else, in having the tank empty. I mean, I've had transactions where somebody says, well, we've lived here 5 years and we haven't had to empty the tank. Well, the reason for that, mate, is your tank's leaking. So that obviously immediately produces problems. So it's not as straightforward simply saying.
No, it isn't. I've got one. Well, I've not a septic tank. I've got a Clargester small treatment plant here in my house in rural Cheshire, where the water's so pure when it comes out you can drink it. So they say. I've got some here, David.
Yeah.
It's very nice.
Yeah.
It's actually water from the tap.
Thank you for that, David. Obviously a really complex area and one where a great deal of caution needs to be taken. Richard, the next question that we've got sounds deceptively simple. What is the position of an executor in a qualifying lease?
This is again for the presumably the leaseholder protections part 5, which is for a long time now been sort of exercising people. The problem is that there's several problems with executors, and I don't think it was thought, like so much of the leaseholder protections, it just wasn't thought out initially. The person who's a qualified leaseholder, again, it all goes back to February the 14th, 2022. It's the day they decided to change all the legislation when it had passed through the Commons and was substantially through the House of Lords and got no scrutiny, which is the problem with it. You can always claim as a qualified leaseholder, with things being equal in a relevant building and so on, a more than 21-year lease, if it was your principal home, and you can claim for up to 3 flats. But if you've got more than 3 dwellings throughout, not just England where it applies, but the whole world, sorry, the whole world, I'm getting that wrong, with the UK, then you can only claim if that flat's your principal home. I remember in the early days of this all coming in June 28th, 2022, some people started asking me about executors. Supposing you had somebody who occupied a flat as their principal home, it's an irrelevant building, in January of 2022, and then they die. And property passes to the executors. Executors derive their authority from the will. You know, the moment you die, Section 1 of the Administration Estates Act says it passes, all your property goes to the executor. You'd be well advised to, you know, before any transactions go through probate and likes. Probably worth mentioning, if you don't have a will or if the executors predecease you, it passes under Section 2 to the public trustee. So if somebody dies in late January 2022, it's now the executor's property on February the 14th. It's not impossible that it's the executor's principal home if they're a close family member, but it's pretty unlikely. And if that executor, it isn't their principal home and they've got more than 3 dwellings throughout the UK, it's not a qualifying lease. People have asked me in courses, solicitors have asked me, well, I'm also an executor. Do I have to take into account my own house as one of those, more than 3 dwellings? And there's no real answer to that. I have heard the Department of Levelling Up say that they consider that the dead person would still be a qualifying leaseholder. I've got news for them that dead people can't actually hold property. So that's one problem with the executors. Suddenly it's not a qualifying lease. Another problem I've come across, because I've started talking to private client lawyers about it, not just conveyancers, because they need to know about it. So I've been talking too much. They need to know about it, as executors will refuse to fill in the leaseholder deeds or certificate and likes that are required. For the same reason they've refused to fill in inquiries, respond to inquiries, because they don't know, basically. And what happens if the executor refuses to fill in the leaseholder deed of certificate? Well, they're in danger of losing the leaseholder protections.
David, anything to add to that?
No, I mean, I think the position is confused, shall we say? I mean, it's like I did pitch a question by indirect means to government on this point, and the response, which is was publicly published in response to questions in the House of Lords, the government, the Department of Levelling Up, said that there wasn't a problem because the deceased remains the owner of the property until the property is sold. Well, I did ask them where in the Act it repeals Section 1 of the Administration of Estates Act, and they haven't actually responded to that point. So quite clearly their understanding of it is, or their interpretation of it is based on an incorrect interpretation of the law. You're right. If the deceased died before the 14th of February 2022, then I think the consensus of opinion is that it's quite feasible that the executor will not be a qualifying leaseholder, because the deceased wouldn't have been a qualifying leaseholder.
I did laugh when I heard this idea that the Department of Levelling Up may have got rid of the Administration of Estates Act, which is pretty fundamental to the law. But I mean, the other thing, which before I had my coughing fit, is if the executors lost the leaseholder protections because they don't fill in the leaseholder deeds of certificate in time, I think they're in breach of trust. And could be sued for the consequences. They've reduced the value of the property.
In terms of whether they need to take their own assets into account, I've seen an opinion of a KC recently, which seems to suggest, in his view, that they probably don't need to look at their own assets on the basis of it's not their assets which are under administration. It's a deceased asset. So, but again, that's not been tested.
That's not been tested, and that's not what the legislation says.
Exactly.
Whether it's intended or not is another matter.
Yeah, indeed. And the attitude of government seems to be that all of these issues will eventually be resolved by the tribunal, which is not particularly helpful. Although I suspect there are a number of barristers who are rubbing their hands in glee at the enormous fees they're no doubt going to generate with all these cases that are going to be produced by clarifying the misdrafting and the appalling drafting within the Act.
The other thing is the TA7s, the new ones, the 4th edition, and also the predecessors. You can't blame them. The new inquiry forms. Ask questions about of the seller. Are you a qualifying leaseholder?
Yeah.
And how many lay people would even come close to understanding that?
Yeah.
And you can understand the secrets to the universe if you can understand that. But it's an almighty mess, and they really need to backpedal and do something about it. I mean, it's not just executors either, David. They forgot about companies. Companies can't have a principal home. Companies are a way of buying properties and investment properties to let. And if the company had more than 3 dwellings on 14th of February 2022,
Yeah.
qualifying for that moment, they forgot about things like attorney, powers of attorney. There's no
Attorney and deputies.
court-appointed deputies and all these kind of things.
There's been a tribunal decision recently on the point about companies, which, I mean, the suggestion is that the Act refers to a person. The Interpretation Act seems to suggest that a person includes a corporate body, but
I can understand that.
But the tribunal has recently ruled that a company doesn't satisfy all the requirements in the Act and therefore can't be a qualifying leaseholder.
Yeah.
So yeah, it's, again, I think that's a bit of a mess which needs to be resolved.
Yep. Mm-hmm.
Thank you. So, David, next question that we're covering goes back to the discussion about septic tanks, and the question is, how often do septic tanks need to be emptied? That's the first part of the question. Presumably less than once every 5 years if they're leaking, from what you said previously. And the follow-on question: does a sewage treatment plant need emptying?
Okay. I would caution anybody who's eating to mute this next bit of the conversation. But essentially, a septic tank and a sewage treatment plant are basically variations on the same thing, in that the effluent passes into the tank. For want of a better word, the solids will settle, and the liquid will be passed through a number of chambers to clean it to a certain degree. As you're saying, if you've got a sewage treatment plant or a Cladrester, as Richard's mentioned, then the output water is allegedly safe enough to drink, although I'm not sure I would be brave enough to try it. But the bottom line is that how often, first question, a point to emphasize is they need to be emptied, because eventually the solids will just build up to a point where the liquids will just simply flow straight through without being treated. So to that extent, yes, they will need to be emptied. How often they need to be emptied, not to put a too blunt a point on it, depends how often you use the loo, or whatever, or how often you use the washing machine, or whatever is going into the tank. It's going to depend on the number of the size of the tank, and the number of people that are using the tank. Yeah, essentially, the average size tank with a family 2 or 3 times a year probably is perhaps not unrealistic. Sewage treatment plants, again, will vary according to the size and the nature of it, and Richard could perhaps comment on how often he needs to have his system emptied.
I'm not at liberty to discuss that.
Oh, right, okay, fine. Yeah. But essentially, yeah,
it depends on the size of the family, really.
Of course it does, yeah. And that's another issue, that if you're acting for somebody who's buying a tank and you've got a single person living in property that says that I need to empty it once every 2 years, well, that's not unreasonable if it's a single person and it's a large tank. But if you're now moving into that same house with yourself and your wife and 3 kids, then it's saying to them we only need to empty it once every 2 years is clearly not going to be appropriate. It's going to be, it depends on usage, basically. But the bottom line is, yes, all systems, whether they be septic tanks, treatment plants, or indeed cesspits, need to be emptied. But when and how often will depend exactly on usage and the size of the tank, and the number of people, and the amount of discharge going into that tank in the first place.
I mean, did you mention discharge permits in your?
I don't remember. Yes, I did. I basically said if you got the general binding rules, and if you don't comply with the general binding rules, then you need a discharge permit. But generally, I've glossed over it to some extent. I was more concentrating on some of the other aspects.
Yeah. So if you discharge more than 2 cubic meters of waste a day, or 5 cubic meters in a Cladrester, treatment plant, Cladrester is a brand name, then you'll need a discharge permit. I always think if you're discharging in a normal house at more than 2 cubic meters of waste a day, you'll probably need a doctor first.
Yeah, precisely, yeah.
You need to change your lifestyle. But it's obviously, like you say, it's things like the washing machine that really discharges of huge amounts. dishwashers and things like this.
I think health advice is probably slightly beyond the scope of this session.
Indeed, yeah.
I'll probably include it in the new residential TA6 5th edition if they're not careful. Health advice, that's the next thing for conveyancers.
I think one of the issues is that people think of the septic tank, they might immediately think about the toilet, but as you say, they ignore the fact that it's all the wastewater. As you said, Richard says, the washing machine, the dishwasher, the bath or the shower, it's all going into the same system. So it does add up.
Yeah. So Richard, we're now moving on to the next question, and we're moving from waste management to building height. And the question that's been asked is, how do you measure the height of a building under the Building Safety Act?
That's something that could occupy the rest of the session. They've again got themselves into a huge mess in terms of the height of the building. The problem is there's various pieces of legislation, not just under the Building Safety Act, but sort of post-Grenfell legislation generally, that depends on the height of the building. Again, this is in England, not Wales, where we're still waiting for the Welsh government to tell us what's happening. But you've got building regs, firstly in England, 2018 and some 2022 building regs, which refer to 18 meters or more in height, and then the 2022 11 meters or more in height. And there's one way, I mean, it's not a lawyer's job to go into this, but it's one way under the building regs to measure the height of buildings. But under the Building Safety Act, there's a totally different way, and it's relevant really in two situations. One, which is the higher risk buildings, where it's 18 meters or more in height or 7 stories, and the other is for what we've been mentioning, the leaseholder protections, which is sort of 11 meters or more in height and 5 stories, or 5 stories an alternative. I do wish Barclays would learn how to spell stories in their part 2, because they've got the work for fiction. Last time I checked a week ago, it was still down there as a fable. But they, in terms of the measurements, I'll tell you the story behind. Early last year, conveyancers started to tell me that valuers won't tell us the height of the building. And I thought, it's not really a valuer's job. Then I started hearing stories about surveyors won't tell us the height of the building. It's certainly not a lawyer's job. It should be a surveyor's job. And the reason was, at the time that RICS, the Royal Institution of Chartered Surveyors, told their members they thought the government's ways of measurement and guidance under the Building Safety Act was so bad that you couldn't commit yourself. Basically, in terms of stories, they are alternatives. You're supposed to measure from, you're supposed to ignore any basement of the ceilings beneath ground level. And you're supposed to ignore any top floor, which is solely plant and machinery as a story. You've come across Wait and Could David? I don't think I mentioned it in my talk, actually. Tribunal decision.
Yeah, that's right.
Wait and Could
No, there you have.
It was about remediation orders as much as anything, but this is why Rick's got a bit panicky, because it was all about whether it's a higher risk building, and the first reports they had said it was 17.55 meters, so it's not a high risk building. The next report they had from a surveyor said it's 17.97, and they built in a margin of error of 30 centimeters, so it's suddenly an 18-meter high building. It's a higher risk building with all the consequences it's that big. And then they had another report that said, in terms of the number of stories, that there was a roof terrace, a shared roof terrace at the top, on the roof is an obvious place for it. And they thought that on the definitions would also be a story, so it's well over sort of the height of the building. I came across another one in relation to stories, that it was a block of flats which was 4 stories high. Somebody was asking me about this just before Christmas. It was 4 stories high, and it had a ridged roof, and the ridged roof was boarded up for storage, and collectively people would store things in the ridged roof. And is that a 5-story high building? I think it probably is. And they didn't deal with that, just dealt with the top floor plant and machinery. Yeah. And in terms of the height, quite separately, you're supposed to measure from the lowest point of the ground floor, but not to the top of the top floor, but to the finished floor of the top floor. So if you've kept over the too long during 1970s shag pile carpets, then that won't tip you over the edge. It's just the finished floor. And in that Waiting Kadai case, they decided the top floor is actually the roof terrace, and so therefore it's well over 18 meters. I mean, the other problem I've seen is the definition of how you decide on what actually is a building, because if you've got connecting passageways and doorways, unless it's just used for essential maintenance or emergencies like a fire escape, it can be one big building. I came across one where it was 3 stories, one particular part was 3 stories in height, and next door to it was a 6-story high building, and the solicitor was acting on conveying one of the flats in the 3-story high building. There was a connecting passageway, so the 3-story high building also came within the leaseholder protections, and the landlords and the agents just wouldn't have it, just refused to cooperate. The agents ceased instructing the solicitors because they were insisting this is within the leaseholder protections. And I say RICS are basically because of all these problems and differences between building regs and the Building Safety Act, just decided to tell their members don't have anything to do with it. It's certainly not a lawyer's job. The Law Society guidance that for conveyances on the Building Safety Act that came out in February the 14th. Again, they just love February the 14th. But this year says that you should think about limiting your retainer and telling clients, we can't tell you the height of the building. I don't think you should think about it. You do it. We are not there to tell you the height of the building.
Right, I think that's exactly right. I mean, the Law Society guidance has its faults, but there are some bits of it where it's sensible, and certainly the bit that says it's not your responsibility to determine the height of the building is absolutely spot on. Again, this was all part of the same. Some of the questions and answers. I tabled some questions in relation to a statutory instrument for the Building Safety Act last year, and the response from government to some of those was, and one of the questions was, how are you? Who's supposed to determine the height of the building? And the government's answer was, well, it's not the solicitor's responsibility. The managing agents will tell you, which is naive in the extreme. In that managing agents are not
even if they will tell you, they won't tell you what they think. I mean, people say, can we base it on the fire safety risk assessment? That should tell us the number of stories. It's not the same definition.
Indeed. Well, that's basically what the government was saying, that the managing agent will be able to tell you because they have to assess it for fire safety regulation as well. As Richard says, they're different. So managing agents, will, in many cases, I hear this from practitioners all over the country, managing agents will not tell you. They won't commit themselves to it.
I can understand managing agents not actually telling you, but when chartered surveyors can't tell you, I mean, something's gone wrong somewhere, and why didn't they just consult with RICS before they brought it in?
Yeah, exactly. So bottom line is, who knows? It's not your problem, should we say? As you and I as solicitors, it's not our problem.
I'm getting too old, David, to go around climbing up scaffolding and ladders in a high-vis jacket with my tape measure.
Yes, you've got to have access to the top floor flat to find out where the top of the floor is. So that's not always easy. But it's ultimately, I'm afraid you can say literally, but it's not my problem, not my responsibility. You as the client, if there's a doubt about it, will have to instruct somebody who's prepared to measure it. Who that is, well, who knows?
Yeah.
So a slight follow-on question, gentlemen, and my grandmother will haunt me if I don't get this in. The Building Safety Act, what's its status in Wales? That's something you've mentioned a couple of times already, Richard.
Yeah, it's like we mentioned. I mean, what David's been talking about, and the septic tank replacement, if is not in Wales. All in Wales, all septic tanks have to be registered with Natural Resource Wales. But basically, the whole of the Building Safety Act, on the face of it, applies to England and Wales, but obviously, the regulations are going to be different and at different times. The Welsh government were given two, powers to decide in 2 sections what they would include, and it goes back to what we just talked about: the height of a relevant building for the leaseholder protections, and also the height of a building for whether it's a higher risk building in Wales. In terms of, I'll start high risk buildings first. It's complicated, and most of the Building Safety Act, much of it has nothing to do with conveyancing. It's about construction and planning and this kind of thing. But in terms of high risk buildings in England, as we mentioned, it's got 18 metres or 7 stories. And it's also going to have at least 2 dwellings. In Wales, that's for it's called something called the golden thread. That's for both the design stage, the construction stage, and what the conveyancers need to worry about, the occupation stage. That's the definition in England. In Wales, they say they will introduce provisions that it's going to have 1 or more dwelling to be a higher risk building. That's just been different for the sake of it. And 7 stories or 18 meters, but only in the construction stage and the design stage, not the occupation stage. So as it seems that unless there's a change of heart, they're not going to bring it in terms of what's important in conveyancing. In terms of the leaseholder protections, the then First Minister, Mark Drakeford, who retired or resigned or whatever recently, basically said they didn't intend to bring in the leaseholder protections in Wales, because everybody in a flat of 11 meters or more in height building would be able to qualify. Landlords couldn't charge the leaseholders, and and if the landlords couldn't afford, then they would be able to pay money themselves. And that was last year, and so we're still waiting for the detail of it.
Yeah, I saw that. It was in response to a question in the Welsh Parliament, wasn't it? But yeah, essentially appeared to be saying they were not going to do it. Interesting.
They'll pay the money if the landlords can't.
If the landlord won't, yeah, that's right.
The Welsh government can't afford it.
Yeah. I mean, I had a session last year booked to do the Building Safety Act to a group of practitioners in Cardiff. Well, if you want to talk about Wales, we'll be in and out of here in 10 minutes. But if you want to talk about England, then obviously it's a rather different.
The trouble is that a lot of conveyancers in Cardiff are doing conveyancing in England as well. That's You've got almost sort of 2 different distinct sort of courses to do. The other thing that Mark Drakeford said, the First Minister, is that they didn't think they had the same problems. They wouldn't introduce it in Wales. It might be a change of heart. I say most of it's been introduced in Wales. It's just the height, but they might have a change of heart. But they wouldn't introduce it in Wales because he didn't think that Wales had the same problem with high-rise blocks of flats as England does. He's obviously never looked out of the window at the Welsh Assembly, from the Welsh Assembly building and seen what Cardiff looks like now. Right, as far as Penarth, it's just sky, blocks of flats after blocks of flats.
Yeah, I mean, right. It is an issue in Wales, but they just don't appear to be addressing it with any degree of urgency. I've not heard anything further since Mark Drakeford made that.
No, I've not heard anything this last 2 or 3 months.
No,
they got a new First Minister. I mean, it was somebody Jones, wasn't it? Who's the Energy Minister in Wales, who's for some bizarre reason responsible for whether it's implemented or not. So that's it for Wales as it stands at the moment. The leaseholder protections and the occupation stage of the stage for high risk buildings is not in place, but maybe one day.
Thank you, Richard. So, David, next question is returning to the subject of waste disposal. And the question is, how can I be certain whether a drain is a private drain or a public lateral drain?
Good question. I'm tempted to say don't ask the Water Authority because they won't know. The plans and the maps that they have of where the drains are notoriously inaccurate. And in many cases, non-existent to any realistic extent. The general rule is that a drain is private until it either leaves the boundaries of your property or connects to a drain which also serves an adjoining property, at which point it becomes a lateral drain. But of course that's, I mean, if you take the concept of 3 terraced houses, I mean, looking at it from one side to the other, one of the end properties will have a private drain which will connect from their house to the boundary of the property. It then passes over onto the boundary of next door. At that point, because next door will connect into that same pipe, that then becomes a lateral drain and therefore public responsibility, which means that the middle of the 3 terrace houses has got a very short run of private, because they'll only have a very short pipe which will connect from their house to what is now the shared lateral drain, and the same with the one on the end. So bottom line is that the starting point is it's private while it's within the boundaries of your property, unless the pipe also serves an adjoining property, in which case you may well have a public lateral drain within the boundaries. So the only way to know for certain is, say, not to rely on the plans, is to have a full drains survey carried out to determine exactly where the drain runs, and at what point does it pass outside of the boundary of your property, or at what point does it connect to a drain which also serves an adjoining property. So it's not straightforward, shall we say. I mean, the starting point is, if it's within the boundaries, it's private, except unless that pipe is also connecting to somebody else's pipe, in which case it's potentially a lateral drain. So not always straightforward is basically what I'm boiling down to say.
I remember, David, that back in 2011, just before during the big conference, just before I mentioned this, just before the adoption of all the private sewers occurred, and getting into a bit of a row after the conference with a representative of one of the utilities, who assured me that they'd update all the searches within a year, or a absolute maximum of 2 years, and they haven't started.
No.
Like you say, that you just can't be sure. They don't know themselves.
No.
Somebody told me from the days when local authorities used to be responsible for these things. They told me that, I wouldn't mention names again, but a certain local authority, they were trying to, the utilities were trying to get their records of where all the drains and sewers were laid, but they were all held on microfiche, so they decided to destroy them all.
You say you couldn't make it up, but with local authorities and things, it's often the case.
I won't mention names though.
No.
If anyone wants to contact me, I might tell you.
We'll let them know. Thank you. And Richard, staying with you for a moment, question here. Should I be raising inquiries about higher risk buildings?
Yeah, definitely. I think you should, if you're involved in a higher risk building. As we mentioned before, when the residential inquiries, the TA6s, the general inquiries, and the TA7s, leasehold inquiries, changed on March the 25th. And the 5th edition and the 4th edition of the TA7s, the leasehold inquiries, become compulsory unless there's a change of heart if you're on the CQS by June the 25th this year. The TA6s almost doubled in size. The TA7s, the leasehold inquiries, actually got slightly smaller. And I thought if they're going to update the TA7 inquiries, they should have some questions about higher risk buildings in England. And they didn't materialise, because it's important. If you're, again, we talked about the height previously, 18 metres or 7 stories, and all the problems that measuring kind of takes. They have to be registered with the building safety regulator in England. They had to have been registered by October the 1st last year, and come April the 6th, a few weeks ago, the regulator can start calling in for something called safety case reports and various other information, which if you can't provide as an accountable person within 28 days, you're breaking the criminal law and could be prosecuted. It's going to take them a long time to call in all this information, but they could put you under special measures and the likes. The fact that you're breaking the criminal law, if you don't register, could have an effect on your insurance for the whole block. And you really need to raise inquiries in a higher risk building. Well, firstly, is it a high risk building? To which the answer will come back, rely on your inspection or survey, and the surveyors will say, we don't know. But you need to see details of registration of the higher risk building. Going forward, is there any special measures and all that, and so on? My suggestion would be, I mean, there is an open register with Health and Safety Executive website now, government website, whereby you can check if the higher risk building has been registered. But it came in February the 8th this year, but it has a habit of crashing. There are commercial property standard inquiries since September. They've been included, in questions about high risk buildings for people buying the reversions and the likes. And I would adapt those CPSE ones for residential until we hear otherwise. I suppose the other thing to mention is the mortgagees haven't got wind of it. I'm surprised we've not got a section in the lender's handbook about high risk buildings yet.
Yeah, it took them a while to put anything in about the
leasehold protections.
the leasehold protection. So yeah,
5.14.17. We need a 5.14.18.
Yeah,
I've memorised the lender's handbook, David.
Yeah, like well, that particular section.
Yeah. No, I'm appearing on Mastermind with it as my specialist subject.
Subject, yeah.
Part one of the UK Finance Mortgage Lenders Handbook.
I will look forward to that episode. David, going back, I think, to one of the last questions, ostensibly about drainage, and this concerns SUDs, which I understand are sustainable urban drainage systems. And the question is, who is responsible for maintaining an SUD?
Ultimately, the people that connect to it. The sustainable urban drainage system, basically, the intention behind them is to take surface water from a development and dispose of it and try and mimic what happened to the surface water before the development took place. I mean, you think of it, you've got a green field on which water has fallen for potentially millennia, and it's drained away into either soaked away or evaporated or drained into a stream or whatever. The intention behind the SUDs is to mimic that so far as possible. So that's done by various means, either by having soakaways, or if you look at new developments, you'll see that a number of them have got obviously ponds or features which are streams or other things which are incorporated within the communal areas, and they're essentially signs of a SUDS being used. The one thing which is common is that the local water authority, drainage authority, will not take on responsibility for maintaining it. So it's going to remain with the owners of the properties. So on a large residential development, generally with a management company or managing agent or whoever involved, then it's going to be the responsibility of the residents through their service or maintenance charges or their estate rent charges if it's freehold and set up in that particular way. So ultimately, it's the owners of the properties that will be responsible for it. And not the drainage authority. We say this only applies to the surface water. Obviously, the drains, the foul drainage is a different issue that will become the responsibility of the water authority at some point. But the surface water, if it's in a SUDS and if the Flood and Water Management Act schedule does come into effect, then this is going to extend to even more properties. But at the moment, you need to have a SUDS if you've got a major development in residential, which is 10 houses or more. If Schedule 3 comes into effect, then that's going to apply to all developments of one house or more. So these are going to become more prevalent. So ultimately, if you're acting on a purchase of a property with a SUDS involved, you need to be telling your client that it is going to be their responsibility, not them individually, not personally, but collectively with all the other residents. It will be their responsibility to manage and maintain it going forward.
Thank you, David.
Just like a service charge, really. People don't appreciate the fact.
Yeah, it is. Yeah, it's effectively a service charge or
estate charge.
Estate charge, yeah. However you want to manage it, depends if it's freehold or leasehold. But ultimately, yes, it's a charge payable by the residents. Okay,
thank you. Thanks for that. And we've got a few more minutes left. And Richard, I'm going to come to you and ask a question about the Leasehold Reform Bill. The question that's been asked is does the bill solve the problems with rent charges and Section 121 of the Law of Property Act 1925?
Well, that ties up with a little bit with the previous question. Here's a leasehold and freehold reform bill, and it's not all to do with leaseholds. All the things that have been highlighted in the media do. It's not passed through Parliament yet. And bearing in mind what happened with the Building Safety Act, don't be surprised if there's massive changes at the last moment. It's as we speak today on, what day is it, May the 1st, it's I think it's its last day on committee stage in the House of Lords. It's gone through the House of Commons very rapidly. So it will receive the royal assent in the not too distant future. I suspect it's going to be a lot of regulations and potential judicial review before some points come in. But basically, I mean, given its background, there are several types of rent charge, but in the ones you see in conveyancing are either fixed sum, which sort of name suggests, are a fixed amount, often from properties that were built in the late 19th, early 20th century and have never kept pace with inflation. First house I ever bought was in Bristol. Bristol's got loads of fixed sum rent charges. And it was £6, well, no, 2 guineas it was, 2 guineas per year. I had to pay £2.10. There's those kind of figures. You can't create fixed sum rent charges since July of 1977, when the Rent Charges Act came into force. The 1977 Rent Charges Act, but existing ones remain. They actually come to an end in 2037. But you can create various other types of rent charge, and one is an estate rent charge, which basically it can be a nominal fixed sum like £1, and then the rest must reflect repairs, maintenance costs, and the likes. I think there's a golden opportunity to do something, because the problem is Section 121 of the Law of Property Act, which basically says if you don't pay your rent charge within 40 days of it becoming due, the beneficiary, the rent owner, can create a lease over your property and also can enter the premises. It's got a right of entry. And there was a case called Robertson Lawton that said that means, back in 2016, that said that means what it says. And also that if you then pay off the arrears, the lease remains, and your property is unsellable or unmortgageable, and you have to pay a large sum of money to surrender the lease before you can do anything. I wish they'd done something a bit wider. I wish they could define in the Leasehold and Freehold Reform Bill what actually is a rent charge and all these things called maintenance charge and estate rent charges, but they missed out on that. As time is at the moment anyway. But they say there's going to be reform of regulated rent charges. Firstly, that you wouldn't be able to take enforcement action under a regulated rent charge unless you give a standard pro forma notice and wait 30 days and show proof of receipt and this kind of things. And secondly, Section 121 of the Law of Property Act, the ability to create a lease and enter the premises, wouldn't apply to regulated rent charges. But as it stands at the moment, a regulated rent charge is a fixed sum rent charge, and it's not an estate rent charge. That is very good news for the inhabitants of Bristol and Greater Manchester, where you get loads of these things, but not for most of the country.
Yeah, and I did see in the final debates in the Commons that government actually said they had taken a positive decision not to include estate rent charges. So it's not we forgot to do it. They thought about it and decided we're not going to do it.
Well, I think the problem is this is why you should vote for me in the next general election, David. But the threat of creating a 99-year lease over your property if you don't pay your dues is a good threat and makes people pay. Yeah. The problem is that Robertson Lawton case said that if you do then pay, I mean, we were talking there were fixed sum rent charges between £6 and £15 per annum. If you then pay off the arrears, then the lease remains.
Yeah.
That's the problem. They should actually have done it's actually a nationwide part twos, and have something whereby if you pay off your arrears, the rent charge has to be surrendered on a reasonable admin cost. That's the problem.
Yeah. But yeah, no, you're right. The bill was an opportunity to resolve the problem. They've taken a positive decision not to resolve the problem. I smell vested interests. But yeah, there we go.
So, thank you very much, gentlemen. Sadly, I think that is all that we have time for today. We're getting towards the end. So can I thank both of you, David Keithley and Richard Snape, for really informative session. I've learned things I never thought I would learn about waste and drain management and property today. So thank you for that. Thank you, everybody who's watching, for watching the Law 2024 online residential property Shape the Debate with me, Lawrence Howland of How Compliance. And I'd also quickly like to remind people to join the Solicitors Group Law 2024 online community on LinkedIn, so you can continue the debate and also be included in the exclusive offers that are offered through there for future events. If you purchase the online course, there's still time to watch the other pre-recorded content, and your expiry date will be displayed next to the webinar. For those of you that haven't purchased the online course, there's still time to do so. You can buy the complete event, including a recording of this session. And to book that, just go to www.thesolicitorsgroup.co.uk. You'll also find the online exhibition there. And the exhibition is open to anyone to visit. If you book the entire package, you can claim a free 1-hour CPD webinar from the webinar learning catalogue worth £35 plus VAT. And finally, after you've viewed the online course, please do complete the feedback form that's available to you in the related links section. You will receive your CPD certificate via email. Please feel free to make any comments, positive or negative, about the course. They're always useful to us to know how the courses are received and how to improve things in future. Thank you, David and Richard, and thank you everybody, and have a great day.
Thanks.
Thank you.